My name is Roger. I'm from Illinois. I just had honestly a pretty quick, straightforward question for you regarding constitutional law. I kind of hit a dead end researching the 11th Amendment.
Okay.
I've heard you briefly mention that it's really regarding the corporate structure of the United States. And what they say about it, like on Wikipedia, is that it was adopted to overrule the U.S. Supreme Court's decision in Chris Holm versus Georgia,
Yeah,
which of course was
Chisholm versus Georgia,
hard.
exactly. 11th Amendment. I know what you're talking about.
So, like, of course, they can't overturn the sovereignty of the American people. That's
Nope.
where the authority
Nope.
comes from in the first place.
I
So,
agree.
what are they? What is it really doing? I don't understand what.
Okay, I'm gonna tell you what it is. That's a very good question that you just asked, and that where the confusion comes in is, first of all, there are these two United States. All right.
Yeah.
The word United States and the word United States of America are two separate things. Okay, the word United States is a proper noun. The word United States of America is descriptive, is adjective describing the all 50 contingent states coming together collectively to form the nation. All right, so one of the things that we have to understand is, okay, these words that they're using. And where does this come from? This loophole comes from Article 1, Section 8, Clause 17. I've read tons of case law, and the judges will always, they have this thing called the political question doctrine. And what the political question doctrine is it is obeying the principle of separation of powers. The principle of separation of powers dictate that each of the branches of government cannot infringe on the constitutional duties of the other branch. Okay, like for instance, the executive branch cannot write laws. All right. However, what they do is that they can delegate a portion of the authority to the executive and judicial branches in order to achieve some common goal that they need achieved. That is why they will, if you can Google this right now, you don't have to believe anything I'm saying, just get to Google right now and Google delegation, legislative delegated a power to the Supreme Court, or to Article 3. Article 1, delegating power to Article 3, or Article 1, delegating power to Article 2. Okay, you got to understand all these principles and everything that are being discussed. All right, so when you're reading this case law, okay, they say it didn't overturn anything. That's why that guy, what's his name? I'm gonna give you the I'm gonna give you this law professor.
Okay.
This dude right here, he's real good.
Well, Anthony Scalia has a great video where he's talking to a congressman and they're asking, what if we're talking about breeding dogs? Of course, we're talking about commerce here.
We're talking about commerce,
And you
exactly.
delegate power. Yeah.
That is the question.
Delegate power.
You're talking about moving in commerce. Is what he told me. That's the role of the Supreme Court justices under the Constitution. I'll post that video in the chat room as well. But that is definitely a very good video to watch. But right here, I just posted a link. This guy right here is somebody you need to follow. His name is Randy E. Barnett. Okay, it's a couple of them out there. They are telling the truth, and this is one guy that's doing it. And here he goes. He says, Chisholm versus Georgia was the first great constitutional case decided by the Supreme Court. In Chisholm, the court addressed a fundamental question: who is sovereign, the people or the state? Okay, it adopted an individual concept of popular sovereignty rather than the modern view that limits popular sovereignty to the collective or democratic self-government. And that's what they try to give you today. They try to tell you that sovereignty today is deposited as a collective in government. All the powers of the people have been deposited collectively in the government. And that is not a Republican form of government. That is some sort of democratic form of government, which does not exist under the Constitution. You don't see the word nowhere in the Constitution. You don't see it mentioned in the Federalist and Anti-Federalist papers. You don't see it in the Declaration of Independence. And you damn sure don't hear it said in the Pledge of Allegiance, because I ain't pledged no allegiance to no damn democracy. I pledged allegiance to a republic for which it stands. All right, so it goes on. It says, It denied that the state of Georgia was a sovereign entitled, like a king of England, to assert immunity from a lawsuit brought by a private citizen. Despite all this, Chisholm is not among the canon of cases that all law students are taught. And this is why you're talking to these ignorant law students, because they aren't taught this in law school. And he's going to explain why it's not taught. It's not taught in a what do you say? It's not taught in a sequential way. You know, they don't go by the first case, the second case, and the third case. They start them in the middle somewhere. They start them with that 11th Amendment case. That who was at the Marshall Court? What was it? What was the case you asked me about right now? I think that was Marbury versus Madison. What was the name of the case?
Chisholm.
Well, Chisholm is the first one, but the overturn of the 11th Amendment that allegedly overturned the Chisholm case, I know that was the Marshall Court, but I forgot what case, what was the name of the case that overturned it. But he's discussing it right here. I go ahead and read it right here. He says, he goes on, why not? In this essay, I offer several reasons. Constitutional law is taught by doctrine rather than chronologically. Law professors have reason to privilege the Marshall court, and the court's individualist view of popular sovereignty is thought to have been repudiated by the adoption of the 11th Amendment. I explain why the 11th Amendment did not repudiate the view of sovereignty expressed in Chisholm by comparing the wording of the 11th Amendment with that of the 9th Amendment. I conclude by suggesting another reason why Chisholm is not in the canon. Law professors who follow the lead of the Supreme Court, and like the 9th Amendment, the Supreme Court has deemed its first great decision too radical in its implications. What do you mean too radical in its implications? They don't want the people to be sovereign? You know what I'm saying? I thought that's how America was established. Okay, I thought we got away from kings and all of that. I thought this was the land of the free and the home of the brave. Okay, if it's a free country, I should be able to do what I want to do as long as I don't infringe on the rights and liberties and property of another individual. I should be able to do what I want to do.
Absolutely.
Let me qualify that. All right. So right here, this is a law professor now. It's a law professor. All right. This is an excellent article I read. Constitutional law professors know two things that their students often do not. John Marshall was not the first Chief Justice of the United States, and Marbury versus Madison was not the first great constitutional case. That's why they try to make people think that. Decided by the Supreme Court. That honor goes to Chisholm versus Georgia. So all you anti-sovereigns out there, look me in my face. Look me in my face when you're talking about sovereign citizens and all that. Right there in that case, they told you that the American people was sovereign. I've read it. I don't know how many cases. You ain't talking to some illiterate or something like that that's pushing some sort of conspiracy theory. Anybody with a 7th grade goddamn education can pick up this paper and pick up that case and read what those first Supreme Court justices said about the people of the United States of America. Not you ignorant motherfuckers out there, you police officers, you attorneys, and all you people out there that try to deny the fact that the people in the United States of America are sovereign. Y'all are public servants. You don't dictate to your constituency what our status is. We tell you what our status is. Did you have something else?
Yeah, you definitely have a lot of insight into the understanding of what the 11th Amendment actually did. For sure, I appreciate that.
It didn't do what they trying to do. They trying to, and really, let me tell you, when you read it, the Supreme Court justices understand what they're doing. They're very intelligent men. They understand that the advent of this the 14th Amendment, all these war amendments and all of this kind of stuff changed a lot of things in the country. In the beginning, they understood that the territories, okay, fall under a different jurisdiction than the republic. Okay, in Congress, and this all is tied into Article 1, Section 8, Clause 17. That is the clause that everybody got to study. That is the loophole clause. You can get you a Constitution interpretation and analysis, all right, and you can read that section right there, and you will see the Supreme Court will constantly reference that particular article of the Constitution. okay, when it's talking about the plenary power doctrine of Congress, okay, how within their scope, okay, within the ambit of their delegated authority, they are supreme. They are like kings in that they are the sovereign. It's called a qualified sovereignty. That is the word. Yes, they have sovereignty, but it's a qualified sovereignty. That qualification is based off the fact that we're dealing with territories. We're talking about American Samoa. We're talking about Guam, Puerto Rico. We're talking about all the federal districts and everything like that. In those areas, they are supreme. And they're also supreme when it comes to that social security number, because that social security number is a property that belongs to the federal government. It puts it right there on the card that if they want it, they you're going to have to give it back. So they created a federal person, okay, a federal person, okay, and you are that person, and you fall squarely within the ambit of their delegated authority. And this is where the political question doctrine comes in from Article 3, which is why when you come to them and you try to go to the Supreme Court, and they will tell you that, oh, you got to exhaust your administrative remedies over there first in the district court. Now, you can get on Wikipedia and read and see the United States district courts are not Article 3 courts, they're Article 1 courts. I hate to reference Wikipedia, but that's about the only thing, because it's so hard to find them. That's what the American people should be directly asking. But you can go in the courtroom and ask them. You can go in the courtroom and say, Your Honor, they ask you how you plead. He said, wait a minute, okay, before I plead, Your Honor, I have a question for you. Okay, now, I just got a question. Is this civil or criminal? Well, Mr. Johnson, okay, we just caught you in your car with 2 keys of cocaine and 3 AK-47s. Went to your house, there's 50 dead bodies under the house. This is a criminal matter. What are you talking about? Okay, well, Your Honor, okay, I got it. Thank you. Let the record reflect that the action being brought against the defendant is never you, it's the defendant. Understand that. You're not the defendant.
Yeah.
You always refer to the defendant in the third person. Okay, the action being brought against the defendant is a criminal action. Okay, now, sir, the Constitution for the United States, always put the Constitution in their face. They hate that. The Constitution of the United States, they hate it. They hate it. They think they the only people that can interpret it. They think they the only people. That ain't how the Constitution is written for everybody to understand. It's the supreme law of the land. It forms government and puts a limitation on government. The rest of the powers are reserved to the people. It's your duty to understand the Constitution. To know, all right? Because this is what puts a check on your public servants. And the only reason that they have progressed this far with what they're doing right now is because they understand that their general population has reached a level of ignorance and total apathy where they have capitulated to their influence. They can tell you whatever they want to tell you, and you're going to do it. They're leading you by the nose right now down the road to slavery.